Mic off ആണ് sir. Nasser Master mic off ആണ്.
Hello sir, welcome.
Yes.
Welcome here.
അതെ sir പറഞ്ഞോളൂ തുടങ്ങാം. Sir start ചെയ്തോളൂ. Okay. Good afternoon friends. Today the IQAC University of Calicut is joining with IPRIC, an initiative of Government of Kerala under the State Council for Science and Technology, in organizing a webinar on IPR and patenting system in India. And actually this is meant for research scholars and faculty members of colleges, universities and other research institutes all over India, which is organized by the University of Calicut, mainly for the faculty members and research scholars of the campus. Actually, we are going to enter into the fourth cycle of NAC accreditation next year, and it is in this backdrop we are organizing this webinar on patenting system and procedures. Actually, we have to appreciate the government of Kerala for starting IPRIC to help research scholars and other faculties in Kerala to start procedures for taking patent, copyrights and trademark registration, etc. Today we have with us people in charge of IPRIC like Dr. Ajit Prabhu and Shafiq to talk about the procedures. And we have our respected Vice Chancellor Jayaraj sir to inaugurate the session, Vice Chancellor Professor Nasser, Syndicate Member Professor M. Manoharan, Professor Sadish, charge of the IPR system in our Calicut University. We have a lot of faculty members, research scholars from the campus, and there are friends and people interested in the subject from outside campus. So on behalf of the University of Calicut and the IPRIC, I welcome you all to this event. Thank you, sir.
Honorable Vice Chancellor Dr. Jayaraj, respected Dr. Joshi, Registrar of the University, Dr. Manoharan, Dr. Satish, Dr. Shivdasan, speakers of the day, Dr. Ajit Prabhu, Chief Scientist IPRIC, Sri Safiq, KCST, Sri Sabu, and dear participants. Good afternoon. It's my pleasure to preside over the webinar on intellectual property rights and patenting system in India, jointly organized by IQAC and IPRIC. As we all know, in scientific research, apart from research publications, IPR and patenting are major yardsticks to measure the output. Apart from the fact that IPR and patenting allow us to protect our inventions and innovations, it also brings recognition to individuals, institutions, and all around the country. And many a times we will not be aware of the potential of our inventions and innovations and tend to publish our research finding in scientific journal, which will be available in the public domain. And by doing this, we lose the opportunity to realize the full potential, sometimes including commercial, of the research findings. If we can make aware the students and the young researchers about the various intricacies and potential of protecting the intellectual property rights and also scope for patenting, it would facilitate technology development in an institution. I'm sure this webinar, apart from providing general awareness to all the participants, it will give several insights into the integrated process of IPR and patenting. Our Vice Chancellor has been highlighting the importance of patents, and I compliment the organizers for selecting this highly relevant topic for today's webinar. I wish the program a great success, and I'm sure all the participants will derive immense benefits out of this. Thank you. So now I request the Vice Chancellor to inaugurate the function.
Good afternoon, Professor Nasser, the President of this function, Dr. Shivdasan, Director of IQAC, Professor Manoharan, Syndicate Member, Professor Sadish, Dr. Joshi, Registrar, Dr. Ajit Prabhu and Dr. Shafiq, the resource persons. On the outset, I congratulate IQAC for organizing a webinar in collaboration with Ipr, Intellectual Property Rights Center, Kerala State Council for Science and Technology, on an appropriate topic, IPR and patenting in India. In a higher education institution, which we boast and which we say that it's a center for creation of knowledge. If it is so, we have to protect our knowledge which we have created. The present scenario that compared to the olden times, which we say that all the knowledge created is free and it's for free for all. Things are changing. We have to get due credit for the knowledge which we have created. There is an ample scope of generating revenue from what the knowledge you have created. Concerning the research scholars and research supervisors, there are a lot of misconceptions about the patenting activity. They are worried about the intricacies involved in patenting, and they worry that whether they can publish if they are going for a patenting. And there are a lot of misconceptions which are not clear to the students. So I hope that this webinar will address these problems and make aware of the students how you can go for a patenting. And as from the administrative point of view, if UGC is insisting for 2 papers for submission of thesis, I should say we should also include one instead of one of the paper, even filing a patent is we can consider it's equivalent to a publication. In that way, the students can get the due credit before the realization of the patent or before the award of the patents. There are provisions for provisional patenting, which means that even if you can patent an idea, it need not be a realized thing. You can even patent an idea. There are certain procedures and steps involved in patenting, which I think that Dr. Ajit Prabhu will be explaining to you. You have to make a detailed note of your invention or innovation and drawings, which has to be, then you have to search the novelty or the whether it's already patented. So there are certain steps involved in filing a patent, which I think Ipr can help and clear the doubts to the students. Even in social science, because whenever everyone speak about patenting, everyone's mind is think that it is only about the innovations, process, and inventions which can be patented. If not so, we can patent even ideas and even social science. There are possibilities of having patented. One of the points from which we have to consider is due credit to the students even if they file a patent. In that way, we can attract the students because they will think that there is no benefit of filing a patent. They will be always trying to publish it so that they can submit the thesis. We should make the regulation in such a way that those students which file a patent, even the patent number is not awarded, if they file a patent, we can consider it equivalent to a publication, and that student can submit the thesis. Even though I had a long research career, only towards the end of my research career, I also entered to have some 3 patents I have filed. Only one has awarded. So this is because there was a lack of awareness about the process of patenting and the benefit of patenting. I think the IQAC has taken a right step by introducing how the IPR and patenting works in India. I think it's start from the research coursework, even the research ethics and copyright issues. Then leads to that awareness itself is leading to the issues of IPR and patenting and the possibilities in India. That should be included in our coursework, so that the students get an awareness of what is patenting, how it's easy to patent, and what are the benefits on patenting. I do not want to prolong more because Dr. Ajit Prabhu and Shafiq will be discussing the issues related to IPR and patenting in India. With all your permission, I declare this webinar inaugurated. Thank you.
Thank you, sir. So I request Dr. Manoharan, Professor in Statistics and Syndicate member, to speak a few words.
Sir, am I audible?
Yes, sir. Yes, sir.
Okay, thank you. Respected Vice Chancellor and respected Pro-Vice Chancellor, Registrar of the University, and my dear friend Dr. Shivadas, Director IQAC, and the esteemed faculty members and other colleagues in the university, and the chief guest, Dr. Ajit Prabhu and his colleague, Dr. Shafiq, and ladies and gentlemen. At the outset, let me record that IQAC, in association with Ipr, is conducting a very important program, the webinar on IPR and patenting system in India, in this afternoon. This is the right time because the university has recently come up with a IPR policy, a draft proposed by Professor E.K. Satish of the Department of Commerce and Management Studies, and we will soon be finalizing that IPR policy in the university. And also, several of our colleagues, faculty members in various departments have, to their credit, some successful patents. And also, as our Vice Chancellor was mentioning, it's very hard to get through the patenting systems. All of us know the technological developments in the 20th century have transformed the majority of the wealth-creating work from physically based to knowledge-based. So that is the main idea here. So technology and knowledge are now two factors of production. So obviously, with the increase of information and global workforce, the knowledge and expertise can be transformed instantly around the world, and any advantage gained by one company can be eliminated by a competitive improvement override. This is what is happening in our research works as well. We will propose something, and some other guys would come up with a better or maybe some suggestion, and that will be a better thing. So this shows that there would be a need for creating an ecosystem for promotion of particularly knowledge-driven entrepreneurship, with a major emphasis on creating an environment and a system to provide due protection to the intellectual properties. And this can be achieved by creating a stringent IPR regime in the campus. So IPR very broadly are rights granted to creators and the who is doing the work, and that are results of human intellectual creativity. So these works can be in the industrial, maybe in the scientific, literary, and even artistic domains, which can be in the form of an invention, maybe a manuscript, maybe a software, maybe a suite of software, or a business name. So there are certain legislations, and we are not very much familiar with these legislations and the procedures. The guidelines are there relating to the procedure for filing the patents applications in India. And I'm aware of the fact that there are several amendments also to the patents. While I was the director of the IPAC, we have examined those points, the acts prevailing in the country. And patent started in 1970, and there are quite a few amendments to the act also. So the main purpose for this program may be to create an awareness among the faculty members and researchers about the patent systems in India, and also to provide user-friendly guidelines for obtaining and maintaining the patents under the existing patents law. I hope this program will be of significant help to everyone in the campus, our faculty members and research scholars and students, and also to people involved in the innovations and invention activities towards protecting their intellectual property rights arising as an outcome of their efforts. So this is only a preliminary steps towards creating awareness about the IPR, and I hope this particular program would be very much beneficial and helpful to everyone in this campus. Also, I congratulate IKC for holding such a wonderful program. Thanks. Yeah.
So thank you, sir. So I would request Dr. Joshi to share his thoughts. I hope Joshi sir is here. So I think he is not here.
He's not. Yeah, he's not in the meeting now.
So I would request Dr. Satish, who is also the coordinator of the IPR cell of the university and professor, Department of Commerce and Management, to give his idea or share his ideas. Thank you.
So, thank you, sir. Thank you, sir. Respected Honorable Vice Chancellor, Professor M.K. Jairaj, Pro Vice Chancellor, Dr. M. Nasser, Member Syndicate, Professor Manohar, IQAC Director, Professor Shivadasan, our distinguished guest of the day, Dr. Ajit Prasad, distinguished faculties of University of Calicut, researchers, and my dear students. At the outset, I am very much thankful to the university for giving me an opportunity to draft the IPR policy with the help of law department of this university. And we are in the process of vetting this policy rigorously by various bodies of the university for possible implementation in the nearest future. Even though we have completed half a century of its existence, the ecosystem has completely changed, and the university has to compete with the many other institutions, perhaps the autonomous colleges, private universities, and even the affiliated educational institutions of its own. So the competition coming from various sectors is giving us greater opportunities. This is high time to set priorities for the universities and pinpoint our area of researches. As part of the IQAC team, in the last cycle of our NAC accreditation process, I could observe many potential areas in the university, cutting across various disciplines. And prominently, most of them belongs to the science discipline. But equally important is our languages, history, then folklore, and totally unexplored area is our collections, precious collections, and attached with the Malayalam department. That is still to be a treasure of knowledge is still there, and our researchers need to be explored that much, and that must be patented. And it is, even though better late than never, we are going to implement IPR policy in the university in near future. So our university requires strategic planning for the next coming year and for the next 5 years, 25 years. Otherwise, the university may cease to exist unless we change accordingly. Anyway, I take this opportunity to congratulate IQAC and its director for bringing out this kind of webinar to create awareness among the stakeholders, various stakeholders of this university. Anyway, I am sure, and this will be a great leap and a step to for the future growth of this university. I want to pinpoint one more point, that the recent the Rabindranathan committee report, we have been asked to self-sufficiency in various domains. Government is withdrawing from various conventional areas of its business, and therefore we have to be self-sufficient and truly autonomous one. And I hope that we will be able to generate income by our commercializing some of our inventions and researches. I sincerely wish all the best to the IQAC and all the researchers in this university. Thank you very much.
Respected Chair, let me inform that Dr. C.L. Joshi, Registrar, informed me that he is right now in another meeting at the TLC. So he has conveyed his best wishes to the webinar. Thank you.
Thank you, sir. Thank you, Sadiq, sir. So next I would like to invite Dr. Ajit Prabhu, Chief Scientist, KSCSTE, and Nodal Officer IPR, to deliver his talk on the overview of intellectual property rights.
Honorable Vice Chancellor Dr. Jairaj, respected Chair of this function, Pro-Vice Chancellor Dr. Nasser, my friend Dr. Shivadasan, Dr. Satish, other distinguished faculty, professors, research scholars, and dear students. First of all, let me congratulate on behalf of Kerala State Council for Science, Technology and Environment for the Vice Chancellor on his new assignment as he being a very scholarly person with his rich vision. I am sure he can take this university to higher heights because his profile speaks so. He has got immense experience in Tokyo and other universities and other countries, and I also congratulate his initiative through IQAC to organize sensitization programs on intellectual property rights, especially patents. And I am sure a visionary leader like Dr. Jairaj can increase the IP output of Calicut University. As all of you know, the ranking of many universities among the in the various indices, one of the indices is number of patents and other intellectual property rights that university is possessing. If you look at various universities outside India, even private universities, you can see from their website that they are owning average 300 to 400 patents in an year. That means that kind of intellectual work is going on there, and new inventions and research is happening. I don't want to underestimate our universities. I am quite sure that our universities are equally or even better than that, but it does not reflect in terms of number of patents and all. As the scholarly Vice Chancellor has pointed out, one of the problem or drawback may be the lack of awareness about patenting and IPR. Of course, it is an area where a lot of myths are there, lot of confusions are there. Many people think it is a very cumbersome process, and it is, but it is not so. Of course, universities are the nurseries of invention. Absolutely. Lot of research and lot of innovations are happening in universities, especially like in Calicut University. But that is not being converted into patents and other IPR. How can we do that? So what is the significance of intellectual property rights? That is what I am going to quickly give an overview within half an hour. Subsequently, what is the patenting process, how it is done, those aspects will be covered by my friend Mr. Safi, my colleague and friend Mr. Safi. So kindly permit me to go to the presentation mode. I have a short presentation. One second. Yeah, presentation. Yeah, just 1 second. I will go to the presentation mode. So before starting, I once again congratulate IQAC for organizing or taking lead for organizing webinars on intellectual property rights. Of course, Dr. Shivadas was in continuous contact with me for the past 1 month, and I know he was busy with so many other activities, but still he was in constant touch with me to organize this program. I am sure along with him, Dr. Satish and many people will be there. Can you see this presentation? Dr. Shivadas, can you see this?
Yes, sir. Yes, it is okay, sir. Fine.
Okay. So, how to protect inventions and creations in this knowledge century? Of course, in the presidential address, respected Pro Vice Chancellor Dr. Nasser was talking about knowledge economy, knowledge century, etc. Why it is called knowledge century? Because knowledge is so powerful. Knowledge is the source of wealth and everything. Knowledge, actually all kinds of inventions, innovations, ideas, improvisation, everything resides on knowledge. So knowledge is very important. So how to protect your inventions and creations? That is the most important thing. As Honorable Vice Chancellor was mentioning, there was a feeling that knowledge is free, knowledge is not owned by anybody and all. But now we are forced to think in protecting it. Earlier it was not so. I always compare this IP aspects with our traditional immovable property, landed property. Of course, I think in our ancient, maybe or even our previous generations, do not use any fencing even or even compound wall or anything. Those things came recently only.
Please correct me if I am wrong. So why the generations before our maybe first or second generation before, there was no necessity of protecting. Everybody know, oh, that property belongs to so and so. Nobody will do any harm. But now it is not like that. That landed property has become very precious. It is very valuable. Even a single square inch or cent is expensive. So we need to protect it with the right boundaries, fencing or compound wall or anything. Similar is the case with intellectual property rights also. The world wants that. The world economy goes in that direction. If you do not protect your intellectual property, you will be the loser. If you do not protect your landed property with proper fencing or compound wall, somebody else will take your property away. Same thing here also. If you do not protect, somebody else will take away. So necessity has come to protect your intellectual property. So intellectual property system or intellectual property rights is the system to protect your inventions and creations. So what is intellectual property? It refers to the creations of mind, inventions, even innovations. Slight difference between invention and innovation. Innovation means it has got commerciability, practical application. Literary and artistic work, as Dr. Satish was mentioning. Symbols, names, images, and designs. Anything can emanate from our knowledge or intellectual property. So intellectual property is that which results from the creations of intellect in industrial, scientific, literary, or artistic field. And intellectual property right is the legally enforceable exclusive right granted to the owner of the intellectual property for a limited period. So it is the legal right that is enforceable and it is given as an exclusive right to the inventor. So what are the purposes? There are a lot of purposes for granting IPR. To give official recognition to the creators. Honorable Vice Chancellor was mentioning that researchers should be recognized and they should be identified with patents and other kind of IPs. Yes, of course, that is a recognition. Of course, it is a recognition for the institution and university too. How many number of patents are there? That takes the university's standing to the higher level. And also it is an incentive towards creative endeavors. If you come out with some invention, you get a lot of royalty and lot of wealth you can generate, especially in this knowledge economy. So it naturally facilitates industrial growth in a country. It encourages R&D and investors in R&D and so on. So many benefits are there for granting. That is why IPR is granted. So as per TRIPS agreement, there are 7 forms of IPR. Those are patents, copyrights, trademarks, industrial designs, layout designs of ICs, geographical indications, and trade secrets. These are the 7 forms of intellectual property rights as defined by TRIPS. So I will briefly give an overview, then I will go to the detailed overview of each item. So you can see the patents. Patents are actually meant for inventions, technological inventions. If you invent something new which is not available in the public domain, that is patentable. So it is meant for inventions, technological products, research outputs, etc. in chemical sciences, physical sciences, and biotechnology, engineering at large. So many inventions are happening. So you can protect it by taking patents. Then copyright, as Dr. Satish was mentioning, literary and artistic creations. Of course, folklore or any other new kind of art forms, or even paintings, drawings, sculptures, even photographs, that calls for copyright registration. Then, of course, trademark.
already I have mentioned that some logos and other things which is very, very important for business. Of course, Dr. Satish is also a right person to speak on that, because in commerce, trademark gives the brand name, brand value, and etc. Now, industrial design, of course, a lot of designs are coming, whether it is vehicle, whether it is a bike, whether it is ornaments, saris, and so on. That can be protected. Similarly, geographical indications, certain unique products like Aranmula Kannadi or Palakkad and Matta, Kanjipuram silk, Darjeeling tea. So all these products have or possess some uniqueness, some special quality, and they come from a particular place of origin, which you can't see from any other places. If it is so, that quality changes. So that for such products, geographical indication is important. Then IC layout, of course, in computers and electronic circuits, IC layouts is very, very important. That can be protected. I can explain it with the help of a phone, mobile phone. You can see here. Maybe you see this is a phone. Assume this is a phone. So you can see it. You can register trademark. For example, Nokia, Samsung, whatever it may. Product 208. Or maybe suppose while you switch it on, it comes with a special tone. That also you can register as a trademark. Then it's patents and utility models. How it works, how it receives calls, how it makes calls, what is the data processing method, operating system, touchscreen technology, and a lot of technologies are involved in a mobile phone to operate. So all these technologies, each one is patentable. Then comes design. You can see every phone is unique in its design. I mean physical design. So how does it look like? The overall shape, size, color, multiple color combination, all those things, you can register as design. Then comes copyright. Suppose it uses some software which is essential for its functioning, user manuals, even certain ringtones and images, all those things can be copyrighted. Then comes trade secrets. Maybe some technical know-how or something you want to hide it from this, that also you can. Of course, GI is not applicable. That is why I have not explained it in this case of a mobile phone. So what is a patent? Already the respected chair has given an overview about that. It is a right awarded by the government of India to an individual or group of individuals. Maybe a single researcher can file a patent, or a group of researchers also can file a patent. That is for exclusive rights. So once you file a patent, you get the exclusive right over your invention, which helps to disallow others to use, practice, sell, or market that invention without your consent or permission. So that is the powerful IP. So you get an exclusive right on your invention. You will be recognized by the whole world as you are the owner of this invention. I always when I talk to students or researchers, I always say this point. You have a patent means you forget about all other things. You will be recognized as one among the elite class of scientists who has got patents. That aspect is very important. Your status improves, your recognition improves. Last week there was a discussion with some senior professors in Kerala University, and one professor was telling, by simply filing a patent, one researcher got admission for MS in Switzerland in some premium university. Another person got admission in Canada, and another 2 or 3 people got placement. So these kinds of benefits are coming as a byproduct of getting a patent. So it is very important. That is why it is called an exclusive right. Nobody else can claim that. As it is rightly pointed out by the speakers, once you suppose you don't, that it is a novelty, there is novelty, but you don't file a patent and you go on publishing it in the form of paper, article, something. But that is a grave mistake. You are actually blocking to get a patent. So please don't do that. So once you reach a research output in your lab, please think in some way or other, is it patentable or not? Just check. How to check, I will explain. Otherwise, you can count on us. Our Ipr will help you to do that patent search and all. Then, if possible, file a patent. Then subsequently, you can go on publishing. So you get the credit of both patent as well as publication. So, how can you know your patent is your invention is patentable? Only 3 conditions you need to look at. Only 3, and out of these 3, first 2 are very important: novelty and non-obviousness. Novelty means any invention that you do, it must be new. Newness should be there. It should be novel. That means it should not be recorded in the public domain. Again, that means nobody has taken any patent over that. There is no publications in the form of paper, article, or anything. So that is called novelty. That means it is not in the prior art data or database. That is called novelty. This is the first time you are doing. Nobody else have done it. So that proves that property called novelty. Then second one is most important, again important, non-obviousness. That means there should be an inventive step. Suppose somebody has invented something and maybe a little improvisation with that, you say this is a novelty. No, there should be clear inventive step to prove that it is an independent, individual, novel invention. That is called non-obviousness. Then third one is, of course, industrial application. Any new findings will have application. So that is a less important thing. So first 2 things are important: novelty, non-obviousness. How to check this? Of course, the second speaker, my colleague, Mr. Safiq, will be explaining to you. Then it will be more clear to you. I am giving an overview only. So, patent, you can see the right side. This is called a patent certificate, or just like a document. You do a lot of procedure and register your property in your name. So you get a title deed, which is the proof that you are the owner of that land, piece of land. Almost like that, this certificate is sufficient for you to prove that you are the owner of this. So you can see Government of India emblem, IP emblem, patent number, application number, date of filing, and so on. So a patent is granted for 20 years from the date of filing. So once you file a patent, it is applicable. 20 years, its validity is there. So a patent has got, of course, a lot of benefits, like you can sell the invention, you can license the invention, you can discuss the invention with the peers or researchers or even publish. Absolutely no problem. So there are a lot of rights of a patentee: right to exploit the patent, right to assign and license the patent, right to surrender the patent, and right to sue for infringement. Suppose somebody is, you find out that somebody is making use of your patent and make economic gain out of that, then you can definitely sue for them. So like this, there are a lot of benefits. So there are product patents. For a product, you can get a patent, and for a process also, it may be chemical process, biotechnological process, and so on, you can get a patent. So Indian Patent Act 1970, amended in 2005, is applicable now. That is the legal law for that. So what is the first step you should do? Suppose you are a good researcher, you are doing good invention. So what you can do is, you should first file provisional specification. Provisional specification is very simple. Whatever thing is available with you, all those things you can record, maybe take a photograph or maybe make a picture, drawing, or whatever it may be, and explain it in detail, and then file a requisite fee and send it to the IP office. Our nearest IP office is Chennai, and in Chennai, that you can get it filed. Even online filing is also there now. So that is called provisional specification. So the advantage is you can continue the research. You can avoid the fear of loss, whether somebody else will take and leak your this thing, that you can block. Then comes provisional. Already I explained. So secure ownership. Also, you get priority date over the invention and prevent others from getting a patent. So after that, you can file complete specification in 12 months time. Suppose then by that time, your research output will be incubated. So I will just, of course, I'm just going very little fast. Just for your inquisitiveness, especially young researchers, don't think that big things only are patentable, nuclear science and something like that. No, this I show you can see an example of a safety pin. You just imagine how small a safety pin is. It has got a patent, and you will be astonished to know the amount of money he has made out of that. You know the purpose of safety pin, and what is the use. So many people are using a safety pin, and it is granted to the Walter Hunt is the inventor, and it in 1849 that patent is granted by United States. So this is sufficient enough to prove that even a small invention is qualifying for patent. Don't wait for big things to happen. Even a small thing, small incremental improvement can qualify for a patent. Even, a bicycle, another example, is a small invention. But, in 1890, it has got a patent. Then another, patent for insulin product, it is a process patent. You can see it is. So I stop it here with for the patents, and so my subsequent, my colleague will explain more about that. And then comes copyright. As it is already mentioned by several eminent speakers, copyright is actually is the exclusive right granted to the owner of a literary, artistic, or scientific work to use or authorize others to use it for its reproduction, public performance, translation, adaptation, and so on. So the main criteria for protection of a work under copyright law is that it should be original. There is no condition like novelty, non-obviousness, etc. That is only for patents. Here the only condition is it should be your original work. Of course, the plagiarism and all other things highly discussed in academic forum comes out from this concept. So even a photograph, maybe any other literary work, writing a book, photograph, paintings and drawings, anything is copyrighted. So it is for literary, dramatic and musical work, including computer programs, then artistic work, cinematographic films and sound recording, broadcasting, performers' rights are there, moral rights. These things are to be explained more. Maybe time is not adequate. I'm just leaving it. So, term of copyright, of course, for patent, it is 20 years. Here, author's life plus 60 years, and 60 years for photographic work, 60 years for cinematographic films, and so on. And Copyright Act 1957, amended in 2012, is now the applicable law for copyrights protection. Then third thing is trademarks. So, a recognizable sign or design or expression which identifies products or service of a particular source from those of others. You can see some examples. These are all examples of good trademarks. Left side top, you see an Apple mark. That is for the iPhone brand, Apple. And that is the world's #1 brand today. And the brand value itself is somewhere around $250 billion US. Suppose you see this was not registered as the trademark of Apple phone. How can you make this much, or how can you claim this brand value? Or maybe when you get the more and more business, somebody else can take away this trademark. Similarly, Google, Microsoft, Adidas, State Bank of India, that is called service mark, because Coca-Cola, V-Guard and whatnot. So anywhere, everywhere you can see trademarks. So it can be a word or mark or anything like Ford, Toyota. It can be abbreviation like IBM. It can be logos. It can be a number, even a letter, a slogan, sound. For example, some Nokia tunes and Nestle tunes, etc. Sometimes even smell is also used to certain countries to distinct one product from the other. Only thing, it must be graphically represented. It must be distinctive and distinguishable, and not deceptive. So these are the concerned laws for that. Now, fourth one is industrial designs. I told you, you can see a lot of tables, chairs, automobiles, etc., with different shapes and sizes. So for this, you can take industry or register industrial designs. You see a lot of bikes, and probably the interesting thing is its mechanism, including the engine, is same, but the market value increases based on its maybe the shape, maybe the color, maybe the size. That is called physical design. That adds aesthetic value to the product. Those things you can register as, of course, design. You can see design numbers and other things for these bikes and other things. So only condition is original, and it should new and original and industrially reproducible. This is the only one condition for industry. It is relatively very easy also to get industrial designs, because patent has to undergo certain processes. But now I can guarantee you that recently we got a patent for College of Engineering Trivandrum that is granted in 27 months. 27 months, that means 2.25 years. They filed in 2018 March, and this month beginning they got that patent granted. So now it does not take too much time. Industrial designs, of course, takes maximum 6 months to 1 year maximum. So it is easy to get also. These are the governing laws, and term is 10 years, and it can be again extended to 5 more years. Already I have talked about geographical indications, some uniqueness like Aranmula Kannadi, which is a reflecting metal mirror, which is very unique in the whole world. Darjeeling tea, then French champagne, Kanjipuram silk, etc., etc. So only thing, 3 attributes: uniqueness, quality, and reputation. So from places in Kerala also, we have got lot of GIs, Nyavara rice, Palakkad and Matta, Palakkad and Maddalam, Malabar pepper, spice, and so many things. Then comes integrated circuits and layouts. Already I have talked about this. So layouts of transistor and other circuit elements, including lead wires, connecting such elements and expressed in any manner in a semiconductor IC layouts. So that also. Then comes the last item, trade secrets. You can know certain items. So for example, the recipe of Kentucky Fried Chicken, Coca-Cola, that combination, chemical combination. Then dairy milk, that chocolate which adds the flavor and the taste. So these are all kept still secret. So that is also possible. Also, this is my last slide. Multiple protection is also possible. Don't think that suppose you have one invention and only one patent is possible. No, I will give you the case of a treadmill. Already, suppose it has got a new drive mechanism. That is a new invention. So you can take the patent for that. Engineering drawing of that, it qualifies copyright. Maybe the software embedded into it, to adjust the speed and other things, you can get copyright. Then external shape, configuration, or how does it look like, design. Then brand name or service name, you can put a trademark or so. Then ICs, if you arrange the ICs in a particular fashion, you can get IC layout protection. Suppose you use certain special algorithm which you want to hide from others, you can file, or you can keep it as trade secret or take copyright. So that is all an overview. So I know I was running through, but still within this half an hour time, I hope it provided an overview about what is what and what to do, etc. How to do, next session will clarify to you. And also, this is our address. You can contact for any kind of service related to IPs, for patents, copyrights, trademarks, GI, designs, whatever it is. This is the address. You can check for note down the email address and the website also. A lot of information is available. And thank you so much. Once again, congratulate Calicut University and Dr. Sivadas for taking lead to the IQAC for organizing a very important webinar on this very significant topic. Thank you.
So thank you, sir, for shedding light on many obscure areas of intellectual property rights. You have made it so clear. It was so lucid. Thank you, sir.
Thank you. Thank you.
So now I'd like to invite Sri Shafiq, Technical Officer, KSSTA, to speak on the topic patenting system in India and patent filing procedures.
Thank you, sir. Is it visible, sir?
Yes,
Yes, Shafiq. Yes.
Okay. So, good afternoon, all respected faculty members, research scholars, and students. The topic which I am going to deal is about the patenting system in India as well as the patent filing procedure. So in the previous session, Dr. Ajit Prabhu sir has given you an overview of intellectual property rights, which includes patent also. So I will be speaking about the filing procedure. So as already pointed by Ajit Prabhu sir, patent protects inventions, new inventions. So the definition of invention means it can either be a new product or a process involving an inventive step and capable of industrial application. That is the definition of invention as per the Patent Act. So only new inventions can be protected by patents. So what patent gives us is the exclusive right to the inventor for exploiting the invention for a limited period of time, that is 20 years. That means within the period of this 20 years, only the inventor can make it, he can use it, and he can sell it. And without his permission, nobody else can do any of these activities for exploiting that invention. That is the exclusive right which has been granted by patents. And what we have to do is, to get a patent, we have to fully disclose the invention to the government. So in exchange of that, government will give us the patent rights. And another important thing is that it's a territorial right, which means Indian patent will be valid only within India. So if we want to get patent protection outside India, we have to file in each and every country where we need protection. And as I said earlier, protection will be 20 years. It is not extendable, and the Indian patent system is governed by the Indian Patent Act 1970. So as you know, the discoveries cannot be patented. You know the difference between discovery and invention. So only new inventions can be patented. So as already pointed, in order to get a patent, we have to satisfy three conditions of novelty, inventive step, as well as industrial application. The section 3 and 4 of the Indian Patent Act covers the inventions which cannot be patented in India. We have a long list of inventions which will not be considered for granting a patent, even if it satisfies the conditions of novelty, inventiveness, and industrial application. These are some of the inventions. First one is the frivolous or the silly inventions, or the inventions which are contrary to the well-established natural laws. Such inventions are not patentable in India. For example, perpetual motion machine, a machine which gives more output than the input. So such things will not be granted patent. And similarly, the inventions which are contrary to the public order or morality, anything which is against the public morality cannot be granted patent in India. Then new form of a non-substance or new property of a non-substance cannot be granted patent because it is simply the discovery, it is not the invention. And similarly, arrangement or rearrangement of non-devices, which if it works independently of one another, such things are not patentable. For example, a bucket.
Excuse me, Shafiq sir. Can you make the screen full screen? Your presentation. It's slideshow in the slideshow mode.
Okay. Is it okay, sir? No, okay, sir. Okay. So arrangement or rearrangement of known devices, if it works independently of one another, it is not an invention. It will not be granted a patent. For example, this bucket fitted with a storage. So bucket as well as storage, if they are functioning independently of one another, so that is not an invention. Okay. Similarly, method of agriculture or horticulture methods are not patentable. But in that case, if you invent a device or an equipment to perform agriculture, that can be considered for a patent. But agricultural method cannot be granted patents. Similarly, anything which is related to traditional knowledge is not patentable because it is not a private property, it is the property of the community. Then mathematical methods, business methods, computer program per se, that means source code, computer program, source code as such cannot be patented, but embedded systems can be patented in India. Algorithms and all, these are all exempted from getting the patent protection, but this can also be applied for copyright protection, will not be considered under patent. Then presentation of information will not be granted patent. Then literary, dramatic, artistic and musical works will not cover under patents. In any invention which is related to atomic energy, that will also not be granted patents. Then method of treatment method, diagnostic method. So such treatment methods are exempted from patent protection. So this is the long list of inventions which cannot be granted patents, even if it satisfies the patentability criteria. Suppose you have an invention. We have got two options. One is we can either publish the invention, or the second option is we can go for patenting. So you know the advantages as well as the disadvantages of publishing. So once you publish your invention, what happens is that the novelty of the invention will be lost. After that, you cannot get a patent for that invention. On the other hand, if you are filing for a patent first and followed by publication, then you will get patent as well as the recognition of publishing. So we always advise that to file a patent first and then go for publishing. So if you are going for a patent protection, what we have to do is, what we have to look is, we have to check whether my invention belongs to the prior art. What is prior art? Prior art means any information which is available to the public in any forms of patents, magazines, websites, journals. That means any information which is available in the public knowledge is called prior art, and your invention does not belong to this prior art. Then only it can be patented. So that is what we will check. So why should we do? Hello? Hello?
Okay, sir.
Okay. So why should we do the patent search? So because we have an idea, we will be working out of that idea, but we will not be aware whether somebody else is doing this same invention in some other parts of the world. Okay. So we want to check whether that invention is new, whether it is patentable. So for that, we have to do the prior art patent search. And also for filing a patent, we have to make some expenses during the filing process. So before making such expenses, we should make sure that the invention is worth filing a patent. So for that purpose also, we are doing the patent search. And based on the search result, the decision on whether to file a patent or not can be taken. And it also gives information about the inventors as well as the owners of existing patents. And we can also identify the competitors for the same technology. So these are some of the online databases which is available freely, in which we can do the prior art patent search. So first one is the website of the Indian Patent Office, where we can find the details of Indian patents. Then second one is the website of European Patent Office, then US Patent Office, and something like that. Then you can go for this Google Patents, www.google.com/patents. So it's the simplest way to do the patent search. Just like we are doing how we are doing the web search, we can do the Google patent search. No rules and all. We can simply type the keyword and you will get all the patent documents. All the patent documents including US patent, European patents, Chinese patents, Japanese patents, except this Indian patents. All other patents will be available in this Google patent search. So out of these databases, you need to check the first one, that is the Indian Patent Office website, to check whether an Indian patent is existing or not. And also you can go for this Google patent search. So by doing this search, this is the website of the Indian Patent Office. There you can see the menu patents. Then this is the menu for doing the patent search. You can type the keywords and you will get the result. So this is the Google patents, that web page, Google patent. I just wrote the keyword like gesture control television, and just I searched it and I got a lot of around 5,27,000 documents. Only patent documents will be cited. Only patent documents. Non-patent documents will not be cited here. Only patent documents will be cited, and you can click on these links and it will go to that patent document. You can read that document and you can make sure your invention is similar to that invention. Yes, this is the web page. At the top you can see you can download PDF. You can download the full patent document, which includes drawings, claims, description, abstract, everything will be there. You can read the abstract first, and by reading the abstract itself, you can make sure your invention is different from the existing invention. So that is the way to do the patent search. So if you are doing the patent search, and by doing the patent search, you came with a conclusion that your invention is eligible for filing a patent, then where should we file the patent? In India, we are having 4 patent offices, with the head office at Kolkata and having branches at Delhi, Mumbai and Chennai. So we have to file the patent application at Patent Office, Chennai. So this is the address of the patent office with website and telephone, email ID and all. Who can apply for a patent? Any individual inventor who is the true and the first inventor can apply for a patent. An individual can apply for a patent. A group of individuals can apply for a patent, or his assignee. If I am the inventor, I can assign somebody else to file patent on my behalf. That is also possible. And in the case of the deceased inventor, the legal representative can file a patent. So any of these persons can make an application either alone or jointly with any other person. That means an individual can file a patent, a group of individuals can file a patent, an individual and an institution can file a patent together. 2 institutions can together file a patent. So any combination is possible in filing a patent. So these are the documents which are required while filing the patent application. Form number 1, that is the application for filing patent. Then form number 2 is the provisional or complete specification. Form number 3, 5, then power of attorney. Power of attorney means normally patent documents are techno-legal documents. And we may need the service of these patent attorneys for drafting and filing the patent application. So if you are filing through a patent attorney, we have to give them an authorization form to file patent on our behalf. So that is the term power of attorney. That is the authorization form. That's all, along with the prescribed fees. As already covered by Ajit Professor, we have got 2 types of patent applications, and in which the provisional specification is very important, because if we have an idea and we are working out on that idea and our invention is not completed, and then we can opt for this provisional specification. We need to give a brief description of your invention to the patent office, and what we will get is that we will get the priority date from the date of filing the provisional specification. From that date itself, we can claim protection for that invention. And the advantage is that we can get the priority and we can disclose to another person, because we have already filed the provisional at patent office. We will get a patent application number, and that number will not be changed till the patent number is issued. So we can disclose it to any other person. You will get time to utilize and commercialize. That time means 12 months time, 1 year time we will get it to complete the invention and file the complete specification. Maybe in the mean time, if you are feeling that your invention is not worth filing a patent, you can drop it down because no other issue is there. You can drop the invention. So that is what provisional specification means. The complete specification, as I already pointed, patent specification is a techno-legal document. That is the complete specification, which should fully describe the invention. All the details of the invention should be described in this complete specification. It should be described in such a way that any other third party can, by reading this document, should be able to reproduce that invention without your help. So that is the way, because patents will be granted for a period of 20 years. So after 20 years, it will be the public property, so that anybody else can use and modify this invention. So it should be described in such a way. So these are the contents of the complete specification. We should have a title, then field of the invention, that is the technical field will be there, background of the invention, summary, brief description of drawings, then claims. Claims is very important, then drawings and abstract. So these are the contents of this complete specification. So first step is the filing of the patent application. You can either file provisional first, followed by complete, or if your invention is already completed, you can directly file the complete specification. Upon filing the complete specification, you will be issued a patent application number. And what they will do is that they will keep your invention secret for a period of 18 months. That is 1.5 years. They will keep it as a secret, and after that they will publish your invention in the official journal. That is the official website of patent office. If you are not willing to wait for that much time, you need to file a request for early publication on form number 9 by paying some fees, the prescribed fee. So what happens is that application will be published within 1 month. So it will be published in the patent journal. Patent journals are usually published on Friday. Every week, Friday, they will be publishing. All the details of your invention will be published. This is the format of the patent publication. Okay, they will publish all the details in the patent journal. Why they are publishing? To invite pre-grant opposition. If somebody want to oppose you in filing this patent application, they can file a pre-grant opposition, because till the publication of your invention, that invention will be secret only. Only you will be able to know whether it has been filed or not. Okay, so by publishing only, others came to know about the filing of your patent application. So they will be given an opportunity to file a pre-grant opposition. Then the next step is we have to give a request for examination, because only by filing the request for examination, your application will be taken up for the examination. There is a time limit is there within 48 months. That is 4 years from the date of filing, you have to file a request for examination in form number 18 by paying a prescribed fee. So what we usually advise is that if you want to get it done early, along with the filing of patent application itself, you need to file the request for early publication as well as the request for examination. Don't wait for this 48 months time, because the patent application will be examined based on the priority date of filing this request, not based on the priority date of filing the patent, only based on the priority date of filing the request for examination. So we need to file this request as early as possible. So once you file the request for examination, your application will be sent to an examiner. Examiner will be a subject expert in your field. So he will check whether your invention has got novelty, utility, inventive step, whether it belongs to the non-patentable invention and all. He will make a detailed study, detailed examination of your invention, and he will issue a first examination report. First examination report. Okay, there is a provision called the Expedient Examination. It has been introduced recently only. Normally, we need to wait for maybe like 4 to 5 years time to get a patent granted. But in order to speed up the filing procedure, Patent Office, the Patent Act has been amended, and the Expedient Examination procedure has come up, and in which who can apply means startups can apply under this Expedient Examination, then small entity, that is MSMEs. Then in the case of a natural person, if there is a female applicant or a co-applicant is there, then they can also apply for this Expedient Examination. Then government departments, government institutions, government companies. So all these categories of people can apply for this Expedient Examination by filing form number 18A. So this is the form number 18A, which has to be filed for Expedient Examination. This is the fee structure for individuals or startups. We have to pay a fee of rupees 8,000, and for a small entity it will be 25,000, and for a large entity it will be the 60,000. That is the fee structure for filing the Expedient Examination. And also in the case of startup, if it is being filed by a startup, they have to fill up this form number 28 also, then they have to submit it along with this form 80A. The advantage of Expedient Examination is that normally it will take some 2 years time to get it done, this examination procedure. But if you are filing for this request for Expedient Examination, your application will be examined within 3 months time, and you will get a examination report within that time of 3 months. So normally the time grant will be the up to 5 years. That can be reduced to maybe 1.5 years to 2 years. Within 1.5 years or 2 years time, your patent will be granted if it is eligible. So this is the first examination report. As I already said, first examination report will be issued to the applicant, and what we have to do is we have to give a reply to this first examination report, because all the queries raised by the controller or the patent examiner will be listed in this first examination report, and we have to give a detailed reply to this first examination report within a period of 6 months. That is the time limit which will be given to you. And if all the objections are met, patent will be granted, or otherwise some hearing will be there. We need to go to the patent office and we have to discuss with the patent examiner and get it done further. So maximum time limit is 6 months time to give a response to first examination report. If you are failing to do that, your application will be abandoned. So if everything is okay, patent certificate will be issued, and it will also be published in the official journal. That means so and so has been granted a patent for this invention, like that. That will also be published in the official journal. Why? There is a provision called a post-grant opposition. At any time after the grant of patent, that means within 1 year from the date of grant of patent, any interested person can give a post-grant opposition against this grant of patent. So for that, it will be published in the journal again. So regarding the renewal fee, no renewal fee required for the first and second year. It will start from third year onwards. So yearly basis, we have to pay it, or lump sum. We can pay it a lump sum. So if you are failing to pay the renewal fee, the patent will be abandoned at that point of time itself. So this is the patent filing procedure, which I already explained in detail. So this is the fee schedule. For filing a patent for individual or a startup, it will be 1,750, and for a small entity, it will be 4,400, and for a large entity, 8,800. So if you are filing through online, this is the physical filing fee. If you are filing through online, for that you need to have a digital signature. If you are filing through online, you will get 10% fee discount from this fee structure. So you can see the renewal fee from 3rd year to 6th year, it will be 880 rupees per year. And you can see as the time goes on, renewal fee goes on increasing. So term of patent, as I said, term of patent is 20 years from the date of filing of patent application, not from the date of grant of patent. Term will be calculated from the date of filing of the patent application. Okay, so if you are filing a provisional specification first, your term will start from that period itself. You may get it maybe within a period of 4 to 5 years time, but term will start from the date of filing of patent application. Then as far as patent is concerned, there is a big myth called, there is something called a world patent or international patent, but it is not like that. Patent rights, as I already pointed, patent rights are always territorial rights. So there is nothing called a world patent or an international patent, but there is a shortcut called PCT, Patent Cooperation Treaty. It's a multilateral treaty. India is also a party to this treaty. So the advantage is that you can file a patent application, ordinary patent application in patent office, Chennai first. Within 6 weeks time, you can file a PCT application in Chennai Patent Office itself. By filing this application, you will get a priority date for your invention in all the 152 member countries in PCT. Priority, you will get priority for a period of 31 months time. So within that period, in whichever country you want to file, you have to file it. Okay, so PCT means single filing will give you priority in multiple countries. It will not be granted any patents. So there is no international patent or world patent. Patents are always territorial patents. And similarly, some other myths like only complex inventions are patentable. It's not like that. As Ajit sir already pointed, safety pin was a patented invention. So simplicity is no bar for getting a patent. Only thing is that it needs to satisfy the patentability criteria. Then publishing is more important. So that was already been pointed. Publishing means novelty is destroyed. And there is a big myth called one can get a patent for an idea. So ideas cannot be granted patents. Ideas cannot be protected by patent. If you want to protect an idea by a patent, what you have to do is you have to convert that idea to a product or a process. So only new product or process can be protected by patents. Then patenting is a recent phenomenon. It's not like that. From 1790 itself, patent system was already been there. Then age a bar to get a patent. It's not like that. Age is not a bar. Education is not a bar. Only thing is that it should be the inventor. That's all. And patent granted in one country is automatically enforceable. As I already pointed, patent rights are territorial rights. So as far as patent is concerned, don't lose the chance of getting a patent by publishing. So if you publish it, then what happens is that, as I already said, novelty will be lost, and don't use it in the public also. So you should make your invention secret till you file the patent application. That's the first thing, and don't wait for the full development. Apply as soon as possible by filing a provisional specification to claim priority. So that's all about the general, the patent filing procedure and all. And just before I conclude, I will just quickly, just 2 slides, I will mention about our center, that is the Intellectual Property Rights Information Center, Kerala, that is IPRIC, which is the nodal agency of the Kerala state for all the IPR related matters and services. We will be providing all the services with regard to patents, copyrights, trademarks, designs, GA and all. So we'll be acting as the advisory center to the state government on the IPR related matters. And we are providing a number of services to the public free of cost. We will be providing technical as well as legal support for filing. we have got an official patent attorney. Through this attorney, we will be providing technical as well as legal support for filing IP. Then we have an in-house prior art patent search facility. The patent search which I mentioned, if you are having any difficulty in doing the patent search, you can apply to us. We will be doing the patent search and we will be issuing the patent search report. And all the guidance will be provided and will be there. And we are having some schemes like providing technical and legal assistance for filing IPs. And we propose to implement a scheme for providing the technical and financial assistance for conducting IPR awareness programs and all. So this is the achievements which we have made so far. We organized 431 IPR awareness programs throughout the state. We processed 991 patent facilitation forms in which patent search was conducted and forwarded the search reports. Out of them, 58 patents were already been filed and 8 patents were granted so far. We established IPR cells in 8 universities, including one in Calicut University, which was already appointed. We established in 2010. So 8 universities, we have already established IPR cells, 14 colleges and DIC Trivandrum. We have brought out the IPR policy and we have been publishing a biannual journal of traditional knowledge as well as quarterly newsletter on IPR, brochures, booklets and pamphlets on IPR. So if you have any queries related to any forms of IPR, we will be happy to help you out. You can contact us, you can either email to us, you can call us. We will be providing all the services with regard to this filing of intellectual properties. So thank you very much for giving me an opportunity to talk about this patenting system in India. Thank you.
Thank you, Shafiq. Now let us leave a few minutes for the viewers to ask questions, queries and doubts. So it is left to the viewers. So be precise and express your questions and also doubts and queries.
Hello. Can you hear me?
Yeah.
I am Dr. Kannan from the Department of Zoology, University of Calicut. So actually we are in the process of filing an IND and we are discussing it with the Cochin University. There is a patent cell. So I would like to know what's the difference between these two agencies, like the KCST and the Cochin University. Say in terms of the filing fee, whether you will be KCST will be bearing the filing fee, or should the university give it? So basically, what's the advantages and disadvantages of these two government agencies in Kerala? That's one question. Secondly, if you publish your patent in their patent journal, then is that hampers your chance of publishing it in a good journal? So these are two queries.
Yeah, I think, please understand that in India, there are only 4 offices for patent filing. One in Delhi, one in Calcutta, one in Mumbai, and the other one in Chennai. So for whole South India, we have to approach Chennai IP office, of which the address has been already shown by my colleague, Mr. Safi. What we are providing, as well as Cochin University or any of the IPR cells which has been created by Patent Information Center Kerala or KSCST, they are providing you technical support and facilitation only. As Mr. Safiq explained, one of the criteria for patent filing is to check the novelty as well as non-obviousness. These kind of technical support and help we are doing, and we don't charge anything for that. But in patent office, they charge for filing, and that fee is actually shown by Safiq, and that is same for everyone, but varies individual-wise, institution-wise, etc. I hope my answer to your first part question is clear. Second part, publication. Yes, of course, good journals, as you have told, especially in the field of botany as well as zoology, some issues are there. But preferably what we suggest is that at least you file a provisional patent and then you can go on publishing. That would be the thing I suggest. Maybe Safi can add something if you wish.
No, sir. That's the point, sir.
Yeah, okay, I understood. So as far as the financial commitment part is concerned, these two agencies will not be doing any part on that. It is the university side, they have to bear the expense, right?
Yeah, expenses for filing has to be met by university. Of course, I am also thankful to the university for coming out with an IPR policy in which actually all these things should be clearly spelled out. Who can take or file patents, who will spend the amount for filing, etc. I hope it will be there in the IPR policy that is going to come out from Calicut University. Otherwise, those things can be incorporated. Whether a professor is free to file or researcher is free to file, etc. Because as per rules, a professor cannot file a patent in his name. It has to go to the university's name. So such things should be spelled out very clearly in the IPR policy. So that will give an answer for your question, who will pay for that. Of course, in certain premium institutes like IITs and some universities in India itself, they earmark certain fund in the research from the research fund for filing patents and all. So those things are internally can be managed within the university, but which should be clearly spelled out in the IPR policy to avoid any confusions or procedural kind of violations or anything. Is it clear, sir?
Yeah, okay, thank you.
Sir, please see our chat box. Some questions are there.
Hello.
Which should I answer? Maybe
sir, one question, sir. Industrial design rights, is it required that we have to make it industrially or just a specimen sufficient?
Specimen is sufficient, but it should qualify for industrial production. Suppose you make very intricate shape, only one is possible, just like what you call a sculpture. You know, some intricate sculpture and all. Those things you can't file or register under design. Am I clear?
Yes, sir. What about, sir, geographical indicator? So humanities and social sciences and scholars can take part in that activity.
Yeah, definitely, yes. You can find out, especially any special unique items emanating or coming out from your region, by the particular name. For example, somebody was proposing in Palakkad area that Rameshwari idli is a unique product. It is a type of idli, but it is a different idli with unique and quality kind of thing. So that qualifies for this thing. Lot of varieties of mango, lot of varieties of other agricultural products, industrial products, all those things in fact qualify for GI.
Sure, sir. Can I ask a question now?
Sir, please.
Okay, thank you, Dr. Ajit Prabhu. This is Yahya from Department of Chemistry, University of Calicut.
Okay.
First of all, I congratulate both of you, Dr. Ajit Prabhu and Mr. Safiq, for providing a wonderful insight here, giving some basic information about patenting and other related aspects, because this is the first of its kind in the University of Calicut. Anyway, many of the research scholars and faculty members might have get some insight into it. I have to ask one fundamental question. Very important aspect is patent search actually. Safiq mentioned that Google patent search will do. My opinion is that Google patent search can provide only some basic information. So my suggestion is that whether your office can provide another workshop on patent search, especially USPTO or patent scope of WIPO, because I think that research scholars from our university need to get some kind of information regarding patent search through patent scope or a PCT database. So will it be possible for you to hold a workshop in future?
Why not? Why not? We will be happy only to do that. We will be happy only to have a workshop on patent searching. And also one more thing I would like to add, what Mr. Safiq has explained about Google patent search is only an elementary search, as you have rightly told. That is just to give you a quick insight into whether patentability is there or not. But as you have rightly told, we have to do in detail by searching various patent offices and all. In case if you have any difficulty, definitely my office can do that. We will do it free of cost. So there is a patent facilitation form. If you visit our website, you can find out, get the patent facilitation form in Word form as well as PDF form. You can fill it up and send to us. We will do that search for you, and we will let you know the result maybe in 2 weeks' time, because to search is a long process. So normally it takes 2 weeks' time, plus or minus.
Thank you very much. Then, Shudha sir.
Yes, yes, sir.
Think of that, and also Sadish sir, IPR cell of Calicut University. That is very much important. Patent search, a workshop on patent search.
Okay, yes, sir. Thank you. There are two more comments have come, sir. An electronic circuit which has some industrial application, is it patentable?
I think Safiq will answer that.
Sir, that IC we can patent it, sir. The layout design will be protected under the semiconductor IC layout that act. But if you are coming up with a new IC, that's a new product. So new IC which has got industrial application, it can apply for a patent.
Then another question, sir, from the Department of Drama. Can experiments in intangible arts like performing art be patentable or just copyright?
Obviously copyright. All art forms are, Safiq.
Yeah, any art form, literary, dramatic, musical and artistic works, such things can be protected under copyrights only. Patent protects only inventions, only new products or process. Other literary creative works are all protected under copyrights.
Okay, this is for the information of the faculty members of my university. Dr. Ajit Prabhu sir has granted us sufficient handbook for distribution among the research departments. So the IQAC has collected these booklets and we are going to distribute it for use in every department. So it is a ready reckoner for our researchers and faculty members interested in taking patent and getting information. So we will be making use of this document for future use, sir. And also we will be in regular touch to have further discussions and helping programs and also webinars, etc. or similar kinds of collaborative work. Okay, thank you, sir.
Other questions? Yeah.
Sir?
Is there a time for questions?
Yes, Manohar, sir.
Yeah,
yes.
It's just out of curiosity. It was a nice presentation by Dr. Ajit Prabhu and Safiq. My question is regarding the patent time. You mentioned that it is 20 years. How is this number 20 arrived at? Is there any rationale behind this 20? And the other question is, now we are all aware of the fact that different countries are now competing to come up with the vaccine for the COVID-19 pandemic. So we are also badly in need of a good vaccine. Now each country wants to develop as its own. So with regard to the patenting issue, how will it be this patenting policy will it be a roadblock to invention of a very good vaccine, especially with regard to this kind of collaborative work? Will it be a roadblock? That is my question. Please, yeah.
Safiq may unmute and speak. Safiq.
Okay, sir. So regarding the patent duration, actually it is based upon the TRIPS, trade-related aspects of intellectual property rights. Actually, TRIPS specifies the minimum level of protection that each country should give to each form of intellectual property rights, and that is the 20 years, which is being adopted in almost all the countries. So it's a general thing.
All the member countries.
All the member countries.
Member countries, okay.
Yeah,
okay.
yes, sir.
It's based on a general consensus or
Yeah.
It is coming under World Trade Organization, WTO, and under WTO there are 3 separate councils, and one council is called TRIPS Council, that is trade-related aspects of intellectual property rights, which deals with the international IP system. So, in that, all member countries sit together and every once in 2 years discuss and revise the policies and other things. So this has been fixed by TRIPS as 20 years. That is accepted by all, I think now 164 or so member countries are there, including India. So it is applicable in all these member countries. Regarding your other question, definitely, like certain drugs, life-saving drugs or cancer drugs, there is a lot of cases also, like Novartis case and all, even one ampule costs even up to 10 lakhs and all. That is one of the, probably the bad effects of patenting, as you have pointed out. But there is a provision called compulsory licensing. In such cases, suppose in India, somebody develops a vaccine, a private person, an individual or a company, pharma company, and they file a patent, and they say, my one ampule costs 1 lakh rupee or 10 lakh rupee. So, those things may act detrimental to the general public or the common interest of the government. So, government can intervene and direct that company to issue the license to manufacture without adding your royalty or any other IP cost.
Okay.
So that provision is there. If that provision is exercised, the cost of patent will not be added on the drug. Otherwise, it will be added.
Okay, yeah.
I'm giving you both the side. Safiq would like to add something?
Sir, no.
Yes, yeah. Thank you, sir. Thank you.
Patent is a very interesting field, sir. A lot of course, provisions are there, as you have rightly told, all for better, what you call society's upliftment and betterment and all. But some people, of course, you can find some misuse and all. But even then, there is provision for that. So, at large, it actually contributes to the economic or socio-economic development of every country, any country. So that is about patenting. So only thing we have to see it in a positive way, in a constructive way. Thank you, sir. Thank you.
Okay, nice. Thanks.
Yeah, IPRIC has become a great blessing, sir. So scholars and teachers can approach IPRIC for all kinds of help regarding patenting. Sir, Nazar sir.
Okay, sir. So thank you, Dr. Ajit Prabhu and Shri Safiq, for enlightening us on the topics, because it has been a really good talk that we could hear from you, and I think most of the participants, almost all the participants, would have their doubts cleared. And as Dr. Yahya suggested, IQAC, I think, will take the initiative to organize a workshop with the help of Dr. Ajit Prabhu and Safiq, because they have been so lucid in how they told us about all IPR and patents. So I think, for me, I think it's a complex subject, but they have made it so clear. So thank you, two of you. So I would like to invite Sri Sabu to give the vote of thanks.
Before coming to my responsibility, let me say that the 2 sessions were highly useful and very informative. I hope that almost all the participants will share my view and have my view. Coming to my responsibility, first of all, on behalf of the IQAC University of Calicut, I express my sincere gratitude to our Honorable Vice Chancellor, Dr. M.K. Jairaj sir, for being with us and for motivating us in all our endeavors. I also thank our Pro Vice Chancellor, Dr. Nasser sir, Vice sir, Dr. Joshi sir, Dr. Manoharan sir, and Dr. Sadish, and also our Director, Dr. Shivdasan sir, for their active presence and continued support. I owe my deep gratitude to the two speakers from Kerala State Council for Science, Technology and Environment, Dr. Ajit Prabhu, Chief Scientist and Nodal Officer IPRIC, and also to Sri Shafiq for their very informative session and for sparing their valuable time in spite of their busy schedule. At last, I also express my gratitude to all those who have registered and participated in this webinar, especially the faculty members, the researchers, the students, and all. Once again, thank you all. Have a nice day.
Thank you, Ajit sir and Shafiq. Thank you all for making the event.
Thank you. Thank you.
Okay, sir. Thank you, sir. Okay.
Thank you all.